Well, thank you all so much for having me and giving me an opportunity to speak today about legal challenges to pretrial practices across the nation. As you've heard, I work for a nonprofit civil rights organization called Civil Rights Corps. We're using litigation as one tool to challenge systemic inequalities in the criminal legal system. And to date, lawyers with CRC have brought nearly 20 legal challenges to discriminatory money bail practices across the country. These systems, in which a person's freedom before trial depends on the amount of money that she has, result in the illegal detention of 500,000 impoverished human beings every night in this country. In May 2016, after several months of investigation, I filed a lawsuit challenging the money bail system in Harris County, Texas. Harris County runs the largest jail in Texas and the third largest in the country. And for many years, Harris County had detained 20,000 misdemeanor arrestees every single year throughout the entire duration of their cases. This is the largest jurisdiction that we or anyone has sued. After filing the lawsuit, we engaged in about 11 months of litigation. There were 2 multi-hour oral arguments on our legal claims, and the parties engaged in extensive discovery. This past March, about 6 months ago, the federal court in Houston held a 2-week evidentiary hearing that included testimony from 13 witnesses, including 5 experts. The judge reviewed hours of video recordings of bail hearings and considered hundreds of pages of documents. District Attorney Kim Ogg filed an amicus brief on our behalf, and the Harris County Sheriff and one of the county's misdemeanor judges, both of whom are defendants in the case, testified on behalf of the plaintiffs. Sheriff Gonzalez and Judge Jordan explained why, in their experience, money bail destroys lives, has a disproportionate effect on communities of color, and makes us all less safe. The county has spent almost $4.5 million fighting this case so far. Following the hearing, we won our biggest victory yet in the fight to end wealth-based pretrial detention. In April, Judge Lee Rosenthal issued a 193-page decision enjoining Harris County from keeping impoverished misdemeanor arrestees in jail just because they can't pay money bail. Her thorough decision included almost 130 pages of factual findings, including an extensive discussion that dismantled every purported justification for making pretrial release and detention decisions on the basis of blunt access to cash. Judge Rosenthal also explained in detail how all of the rigorous empirical research that's available shows that money-based pretrial systems exact extraordinary harms, and yet there's no evidence to show that they yield any benefit that could possibly justify those harms. Since the order went into effect, more than 4,000 people have been released from the Harris County Jail. Civil Rights Corps is litigating bail challenges right now in California, Massachusetts, Tennessee, Louisiana, Illinois, and Missouri, and we're constantly working with jurisdictions throughout the country to reform policies and practices through education and advocacy. I've been asked to speak in some detail about the legal strategies Civil Rights Corps has been using to challenge money bail systems. So I'll try to spend the first half of my time giving you a sense of 3 basic things. First, what are the key unconstitutional features of money-based bail systems? Second, what are the legal theories that we're using to challenge these systems? And finally, what things should we all be keeping in mind as we move away from using money to make decisions about pretrial freedom and toward a more rational and risk-based system for deciding whether to release or detain a person prior to trial? But I'd really like for this to be an interactive session, so please feel free to interrupt with any questions, and after I address these 3 topics, I'll plan to spend the rest of my time answering any questions that you all have. So first, I want to talk about the key features of unconstitutional money-based pretrial systems. It's really important to understand what the systems we challenge look like and who the people are who get caught up in them. The experiences of our named plaintiffs in Harris County illustrate well what a lot of impoverished arrestees go through when they can't pay money bail all across the country. Miranda O'Donnell, who's the lead plaintiff in Harris County, was arrested on a Wednesday afternoon for driving on an invalid license and with no insurance. Her license had been suspended because she couldn't afford to pay traffic tickets, and she also couldn't afford insurance. After her arrest, she was taken to the jail, and then she was taken with about 25 other new arrestees to a room inside the jail where she appeared by video link before a hearing officer. She was instructed not to speak when she went before the judge. And in a hearing that lasted less than 60 seconds, she was ordered to pay $2,500 for her release. And this is what that hearing looked like.
Miranda O'Donnell. You are accused of driving while your license is suspended or invalid or not having insurance, a misdemeanor offense.
Officers were dispatched to a prohibited vehicle traveling northbound through the East Toll Plaza. They observed the vehicle to have a balance of $1,487.25 in unpaid tolls. They conducted a traffic stop. The driver was this defendant. Her driver's license was not eligible, as well as no insurance on the vehicle.
Probable cause is found to hold you. Your bond is $2,500. You do not qualify for a personal bond. You're going to court 5 on your case. The judge there is Margaret Harris. Will you be hiring your own attorney seeking help?
Seeking help.
Thank you, ma'am. Go to your left. LaShea Williams.
During these 53 seconds, Miranda O'Donnell was condemned to a jail cell due to her poverty, even though she'd been prohibited from speaking in her defense, even though no one decided that she was so dangerous she needed to be kept in jail, and even though some other person who could pay $2,500 or even 10% of that to a bondsman would have walked out of the doors of the jail. But Miranda couldn't afford that amount of money. She's the single mother of a 4-year-old girl. She receives federal benefits to provide food for her daughter, and she just started a waitressing job 7 days before her arrest. Because of her poverty, because she couldn't afford to purchase her freedom, when I met her at the Harris County Jail, she spoke to me from behind glass while wearing an orange jumpsuit. She was tearful because she was separated from her daughter. She was worried that she would lose her job, and she was distraught because she knew that even once she got out of jail, she'd be unable to afford to get her car out of the impound lot. And it's taken her most of this last year and a half to get her life back on track. Her story is typical. There are more than 100,000 women in jails across the country. Most of them are there because they can't pay money bail, and 80% of them are mothers. 2 days after I met Miranda, I met Louisa Magruder in another wing of the Harris County Jail. She'd been charged with failing to identify herself to a police officer. After being pulled over for speeding, she was going about 12 miles over the speed limit. Louisa gave a false name because she believed there was a warrant out for her arrest for unpaid traffic tickets. When she was taken into custody and placed in the back of the cop car, she gave her correct name, but it was too late. The wheels of the county's processing machine for getting human beings in and out of jail cells had already been set in motion, and Louisa was taken to the jail. And then, like Miranda, she was taken with a couple dozen other new arrestees to a room in the jail to appear by video link before a hearing officer. And in a hearing that lasted 1 minute and 16 seconds, she was informed that she had to pay $5,000 for her release, or else she'd be kept in jail. This is her hearing.
Ms. Magruder, you have a misdemeanor charge of failing to identify yourself to a peace officer.
Your Honor, suspect was stopped on traffic doing 52 and a 40. She identified herself as Melissa Bryant with the date of birth 3/31/16. I'm sorry, I put 3/31/16. That's clearly not right. It's March 31st of some year. She was arrested on the traffic because she didn't have any identification, and when she was taken in, she admitted her true name.
All right. Misdemeanor case, there is probable cause. All right. Your bond is set at $5,000. Ms. Magruder, do you already have a lawyer hired in Beaumont helping you?
No.
Will hire for this one, or do you need a court-appointed lawyer?
I'm not sure. I'm not sure about
You
a
want to ask
lawyer
for a court-appointed lawyer? If it turns out you don't need one, you can just tell them when you get to court.
Okay, yeah, that's fine, that's fine.
Let's do that. I'll send a request to Judge Carahan in County Court Number 8. If you talk to your family and figure out you can hire your own lawyer, not a big deal. Just tell them when you get to court. All right. Thank you.
Thank you.
Yes, ma'am. Have a seat, please.
As happened to Miranda, during this brief hearing, Louisa was condemned to a jail cell due to her poverty. Even though she'd had no opportunity to speak, even though no one thought she was dangerous or a flight risk, and even though a person who had $5,000 or even $500 would have gone home. But Louisa couldn't afford $5,000. She had 2 kids, had just moved to Houston, and she was looking for work. She avoided homelessness at the time by living with her boyfriend. And like 60% of Americans, 60%, she and her partner didn't have $500 lying around to pay a bondsman. So Louisa was kept in jail. And the same thing that happened to Louisa and Miranda has been happening to thousands of people every year in Texas and in Connecticut and all throughout the country. Although pretrial systems that use money bail vary from jurisdiction to jurisdiction, they share 2 key features. The first is that the amount of money required for release is not determined with reference to the person's ability to pay, and it therefore results in the pretrial detention of only those people who are too poor to pay the amount required. Second, the secured money bail amounts that are imposed and that operate to detain only impoverished arrestees are generally imposed during brief hearings when there's no findings that could possibly justify the pretrial detention of these individuals. There's no finding that the person is such a danger to society or presents such a risk of flight that there's no other condition of release that would sufficiently meet the government's interest in court appearance and community safety. Making a person's pretrial freedom hinge on their ability to pay an arbitrary amount of cash devastates people's lives and it exacerbates poverty. And it also violates the Constitution. So next I want to talk about the legal theories that we're using to challenge these systems. All of our cases challenging the American money bail system make 2 basic legal arguments. The first is an equal protection argument. No one should be kept in a jail cell just because she can't make a monetary payment. If the government would release a person if she had access to money, then the government cannot keep that person in a jail cell just because she can't afford it. Doing so violates equal protection because it condemns impoverished people to jail while people with money go free. Remember Miranda and Louisa. If either of them had had a couple $100, they would have been released. But not only is it unfair to treat poor people and rich people differently when we're talking about pretrial detention practices, it's also important to remember that using bail to detain someone makes no sense. As a historical matter, the word bail has always meant release. And payment of secured money bail is a condition of release that is supposed to operate as an incentive for the person who pays that amount of money to return to court. But if the person can't pay the amount, they won't be in a position where that incentive could ever operate. It doesn't make sense to condition release on something that a person physically cannot do, like pay an amount of money that she doesn't have. So to take Miranda and Louisa again as examples, both were ordered released, but the sheriff was told, don't release them, unless or until they pay $2,500, or in Louisa's case, $5,000. But because no one asked them how much they could afford, the secured financial condition of release in both of their cases operated instead to detain them. Our lawsuits raise a second legal theory that arises under due process, and it goes like this. The Constitution enshrines a fundamental right to bodily liberty, which includes a fundamental right to pretrial liberty. Secured money bail amounts that operate to detain take away a person's fundamental right to pretrial liberty. They function as de facto orders of pretrial detention. And depriving a person of her right to pretrial freedom is a serious decision. She'll be subjected to the humiliation of being jailed, her own clothes taken away. She'll be given an orange jumpsuit. She'll lose her freedom and she'll be placed in a metal cage. She'll be exposed to disease and violence and subjected to the control of jail guards. She'll be forcibly separated from her family, her children, her job, her home, and her community. And it might be okay under the Constitution to do all of those things. But what's clear is if the government is going to do that, if the government is going to take away a presumptively innocent person's right to freedom and keep them in jail, then it has to have really good reasons, and it has to follow really rigorous procedures. The money bail system, as it's been operating here in Connecticut, in Texas, and almost everywhere else in the country, is accomplishing massive pretrial detention without making sure that it's only happening when it's absolutely necessary to deal with a person who presents a real danger to society, and then only as a matter of last resort. As a result, people like Miranda and Louisa and hundreds of thousands of human beings every year end up spending days or weeks or months in a jail cell for no reason other than their poverty. As you saw in the video recordings of Miranda's and Louisa's bail hearings, there wasn't even an attempt to justify their pretrial detention. The only reason they were there was because they didn't have money. And the Constitution does not permit such a casual disregard for a human being's freedom. Put more simply, secured money bail functions as a detention order for someone who can't afford to pay it. As a result, it must be justified by the same standards that are required for issuing a transparent order of pretrial detention, including notice and an opportunity to be heard. There must be meaningful consideration of less restrictive alternatives to pretrial detention, and there must be findings on the record that are reviewable by a higher court that no other conditions of release will adequately serve the government's interest in reasonably assuring community safety and reasonably assuring court appearance. This argument is unassailable as a legal matter, and every court that has examined the question has agreed. The money bail system as it currently operates, where arbitrary amounts of money are imposed in brief hearings without any procedural protections and no reviewable findings of the necessity for detention, can't withstand this due process challenge. And I want to make one other important point regarding the legal theory that our cases are based on. It has nothing at all to do with bail schedules. Whether the amount of money required for release is read from a piece of paper and is the same for every single person charged with a particular crime or who has a particular criminal history, or whether it's plucked from thin air based on the whims of the judge and his mood that day. If the amount is determined without reference to a person's ability to pay it, and the sum operates to detain only impoverished arrestees without any findings that pretrial detention is necessary to address a specific risk, then it violates equal protection and due process. Another key aspect of our legal theory involves an analysis of the ability of money-based pretrial systems to achieve legitimate government objectives. It makes sense that the government wants to make sure that people appear for court and that people who are awaiting trial don't commit new crimes. But using money to make release and detention decisions is a terrible way to achieve these goals. Overwhelming evidence has shown that detaining people using money is actually counterproductive when it comes to reasonably assuring community safety and court appearance. First, pretrial detention causes crime. In the most rigorous study of its kind ever conducted, economists at the University of Pennsylvania studied Harris County, and they looked at the period of time between 2008 and 2013. And they asked, what would have happened if those misdemeanor arrestees who were held throughout their cases on the lowest amount of bail, $500, were instead released? And controlling for numerous factors, they found that these individuals would have avoided almost 6,000 convictions. And over the 18 months after release, they would have committed 1,600 fewer felonies and 2,400 fewer misdemeanors. Think about that. They found that detaining people prior to trial causes crime, and it makes our communities less safe. Another way that pretrial detention increases crime rates is by exerting extreme pressure on impoverished arrestees to plead guilty as the only mechanism for getting out of jail, or as the quickest mechanism for getting out of jail. Louisa Magruder illustrates this aspect of money-based pretrial systems. After spending almost 4 days in a jail cell because she couldn't afford her freedom, Louisa was finally brought to court on a Monday morning, and she was desperate to get home. She was assigned a court-appointed attorney who told her that if she pled guilty, the ADA had offered a deal that would allow her to be released that very day. And so Louisa signed plea papers. And then she was introduced to a pro bono attorney who had learned about her case because Louisa had just filed a federal lawsuit. And that lawyer managed to convince the judge to agree to release Louisa on unsecured bond. So Louisa tore up the plea papers and decided not to plead guilty at that time, and she was released that evening on unsecured bond. Louisa's situation reflects a truism of money-based pretrial systems. For people who can't afford money bail, pleading guilty is typically the price of freedom. And in Harris County, prior to our lawsuit, 84% of misdemeanor arrestees who were detained at disposition pled guilty. And they did so in a median of 3.2 days. And then 67% of that group who pled guilty while detained were released within a day. And 83% were released within 5 days, well before any subsequent hearing would ever be scheduled. But there are huge costs to this type of system. People plead guilty to things they didn't do, or even when they have viable defenses, just to get out of jail. And in fact, as a result of its money-based policies, Harris County leads the nation in exonerations of wrongful convictions, many of which arose from guilty pleas entered by people who were too poor to pay money bail and who saw no way out of jail other than pleading guilty to something they didn't do. Pretrial detention for even a day or two makes it more likely that that person will fail to appear. Miranda O'Donnell, one of our plaintiffs, provides a good example of how that happens. After Miranda's arrest, her car was impounded. She couldn't afford to get her car out of the impound lot, which made it difficult to get to work, and so she eventually lost that job. Once she finally got her car back, she couldn't afford the insurance necessary to drive it, and she struggled to pay the fees necessary to reinstate her license. So she arranged for a family member to give her a ride to court about a month after her release from jail. But the ride didn't show up, so she failed to appear, and another warrant issued for her arrest for failing to appear, this time with a $5,000 money bail amount on it, which she also, of course, couldn't afford. And knowing a warrant was out for her arrest caused her incredible stress and anxiety. Eventually, she was able to get a job, and she was able to save some money. And this past spring, the driving on a suspended license case that had started this whole thing was dismissed after she managed to save enough money to get car insurance and an occupational license. Miranda's failure to appear was not an attempt to evade prosecution. As it is for most people who fail to appear in court, it was a function of her poverty, and it could have been solved with the simple solution of a voucher for a cab. Overwhelmingly, failures to appear are the result of mundane and addressable problems like the one Miranda faced, and which are exacerbated by time in jail. A person can't get a ride. They have a shift at work that they can't miss, or they'll lose the job. Their child care plans fall through. You'd be surprised by how many courts have notices on their doors that say, "Don't bring your kids here." It can present real challenges for folks. And they don't have a Google Calendar, so they forgot what day they were supposed to appear in court, or maybe they had a medical emergency. Because pretrial detention destabilizes people's lives like it did for Miranda, it makes it more likely that they'll miss a court date. Finally, not only does pretrial detention detract from the government's goals of reasonably assuring court appearance and community safety, but it exposes people to the severe health and safety risks that exist in our jails. I'm just going to name a few of those. First, 32 out of every 1,000 people in jail is sexually assaulted. Violence and abuse from guards and other inmates is rampant. There's a heightened risk of death generally and of suicide in particular. And in fact, a quarter of jail suicides occur during the first 3 days after arrest, when most people are being held on bail they can't afford. And in the 6 years before we sued Harris County, 55 people died in the Harris County jail while being held pretrial because they couldn't pay money bail. The good news is that there are simple, cost-efficient, and effective strategies for addressing risks of non-appearance and new criminal activity that don't involve jailing a person. They include text message reminders, rides to court, vouchers for cabs, treatment for drug abuse or mental health issues, help finding a job, reasonable conditions like curfews and stay-away orders, and in appropriate, particularly serious cases, electronic monitoring. In the end, our legal challenges boil down to this. It should be very, very difficult for the government to throw someone in a jail cell who is presumptively innocent. And this is especially true given all of the evidence of the devastating effects of pretrial detention and the fact that no rigorous study has ever found that secured money bail better serves the government's interests in court appearance or community safety than non-financial alternatives. Pretrial systems that make pretrial release and detention decisions on the basis of access to money violate the Constitution because they result in the jailing of impoverished individuals without any of the procedures that could possibly justify a transparent order of pretrial detention. So what's next? It seems clear to many of us working toward bail reform that money-based pretrial systems are on the way out. But how should we prepare for what's next? How do we as a society make rational decisions about which presumptively innocent people should be released and which should be detained? Lately, people seem to point to risk assessment tools as a key solution to the problems that I've described. And they are a huge improvement in a lot of ways. But they also pose challenges and have drawbacks. So I want to take this opportunity to address the promise and the limitations of risk assessment tools. First, what are the benefits? Primarily, they're useful in the sense that they provide empirical evidence for the obvious truth that the vast majority of people who are arrested don't pose much of a threat at all and can be quickly and safely released within hours of arrest. But these tools also have important limitations. First, we shouldn't really be talking about them as risk assessment tools, but rather as needs assessments. Because what they actually do is measure risk absent some kind of assistance or intervention. They're actually pretty useless as a tool for predicting pretrial success if someone is given access to services like text message reminders of court dates or vouchers for rides to court. Second, the data don't support meaningful predictions about who will commit violent crime or flee a jurisdiction. And these are the risks that we're most concerned about as a society. It's rare for either of these things to happen, and so the data just isn't robust enough to draw meaningful predictive conclusions. Third, needs assessment tools cannot answer the question of who should be detained prior to trial, because that's a values question, and it's a political question. And it boils down to this: if risk inheres in the pretrial process, as it does, how much risk should we tolerate? When these tools produce some percentage risk of non-appearance or some percentage risk of a new arrest, we as a society still have to make a values judgment about the level of risk that we're willing to tolerate. Fourth, it's really important to remember, as somebody mentioned during a prior presentation, that baked into these tools is the systemic racial and economic bias of our system, because the risk percentages are based on prior failures to appear and prior convictions, both of which are frequently a function of poverty and racism. And so we need to be really careful when we talk about needs assessment tools as being neutral or not biased, and recognize that they too reflect systemic racism and classism. The last point I'll make about needs assessments is this: they'll be totally useless unless there's a culture change. And I think, again, Harris County illustrates why this is the case. Harris County has had a risk assessment tool and has been using it for decades. And yet 40% of misdemeanor arrestees were detained at disposition prior to our lawsuit. And in fact, the county's pretrial services agency has been recommending for release most misdemeanor arrestees. In fact, release on non-financial conditions without any money bail. But judges and magistrates reject those recommendations in an overwhelming number of cases because their tolerance for risk is so low. And they instead impose money bail amounts that operate to detain impoverished arrestees like Miranda and Louisa. All this is to say that needs assessment tools are useful, and they confirm that most arrestees can be released safely and quickly with minimal supervision or conditions. But they have important limitations, and any new pretrial system must wrestle with fundamental questions about risk, liberty, and what it means to keep a human being in a jail cell. And with that, I'd really like to open it up to any questions that you all have.
Hi. I was wondering if you had thoughts from looking nationwide or from considering other possible models of what an ideal pretrial justice system would look like and whether there's a role of, for preventative detention in some set of cases.
Yes, I think that there is a role for preventive detention in certain exceptionally serious cases, but a decision to detain someone prior to trial should be made only after rigorous procedures have been followed. So I think the new amendment and the rules that New Mexico have implemented are a huge step in the right direction, and that the federal system and the DC system provide models as well, in that they give a person an attorney and they require the prosecution to affirmatively move to detain this person. And then the prosecution has to prove by clear and convincing evidence that this person is a danger to society. And the defendant has an opportunity to present evidence and make argument and sort of ask for other conditions of release that might effectively mitigate that risk. So yes, while I think that pretrial detention is permissible in particularly serious cases, it should be a measure of last resort and only ordered transparently in transparent orders of detention, and only after rigorous procedures have been followed and findings have been made. The pretrial detention is absolutely necessary, and for specific reasons that are set out.
As part of your advocacy across the nation, have you partnered with other advocates who are trying to address these social needs of these people who are coming before the courts? Because it seems like a lot of times it's a solo effort, and if the problem is the lack of services in the community, then how do we address that?
It's a great question. So as part of both our litigation and our advocacy and our education, we work with folks who are participating in the criminal legal system in a whole variety of ways. But I take your question to be more, don't we need a shift in resources, right? And yes, I think that's absolutely true. It's always going to be less expensive to supervise someone in the community than it will be to jail that person. And so in order to create a fairer, a more transparent, and a more equitable pretrial system, there will almost certainly need to be a shift in resources from the jail, from funding the jail, to funding the kind of services and treatment programs that will help people get to court and remain arrest-free during the pretrial period and after. Did that answer your question? Okay.
I guess my issue, I'm not an attorney, I'm a grant maker, I'm with a foundation, and I find this in a lot of criminal justice and juvenile justice reform efforts that the legal system might work in a silo, other people work in a silo. We have a state that is in a budget crisis. A lot of the resources that were formerly in the community are being cut, and probably other states are facing the same kind of situation. So the safety net isn't there, and we run the risk of people being caught up in the justice system again because there isn't anything else, no alternatives. So I would just say that it would make a lot of sense for a lot of the advocates to work intersectionality, you know, housing and other needs that, you know, would hopefully divert some of these people from the system in the first place.
I agree. Yes.
I was pleased to hear you mention that there are things that can be done to reduce the rearrest warrant issue. I mean, it's an epidemic in this country. Connecticut, last I looked, had 39,000 rearrest warrants outstanding, 12,000 for felonies. Now, if those people are going to be arrested under most conditions, they're going to be, even if you don't have a cash bond, they face incarceration for failure to go the previous time. Do you have any suggestions for models that anybody has come up with that to reduce, to put some focus on the reduction of rearrest warrants?
Yeah, are you referring to warrant, like failure to appear warrants? Or
Failure to appear.
Oh, yes. Okay, so there are documented and evidence-based strategies for reducing non-appearance rates. There are companies that provide two-way text messaging services which have shown to increase appearance rates above 90%. The strategies that are used in Washington, D.C., which include appropriate levels of supervision, checking in, part of it is remembering that when people fail to appear for court, it's very rarely because they're fleeing the jurisdiction. It's almost always because something has come up in their life that makes it really difficult to get there. And so the strategies need to be tailored to the people who are at risk of not appearing. And so some of the information that can be useful in identifying where that risk of non-appearance is coming from is to find out, you know, does that person have responsibilities? Are they the sole caretaker for a parent or for a child? Are they going to have difficulty getting childcare? Did they just start a job and they're going to have a shift that they can't miss? And then you need to have some mechanism for that person communicating with somebody at the court to say, hey, I have a shift I can't miss. Please let me reschedule my court date by a day or two. And then the court needs to recognize, and the prosecutor needs to recognize that this is exactly what we want that person to do. We want that person to be having gainful employment, and of course we'll reschedule that court date for a day or two. And so these types of systems that help people who maybe don't have Google calendars like others of us do, sort of remember when they're supposed to be at court, and then helping address whatever challenges exist that are preventing that person from getting to court. These are a lot cheaper than detaining a person until their court date. And if you remember what Dr. Holsinger was saying, detaining someone for even 2 days increases the likelihood that they're going to fail to appear. So one of the strategies is just to get people out of the system as quickly as possible. Don't destabilize their lives by 24, 48, or 72 hours, much less 1 or 2 or 3 weeks in jail.
Yeah, I believe that's what New York does on some of their cases. People are actually held and disposed of within 24 hours. And so
I'm not suggesting that people should be disposing of their case within 24 hours. That doesn't seem like a good system to me. I understand that I don't know if that happens in New York. I understand that happens in a lot of places where people are given an opportunity within 1 or 2 days of arrest to plead guilty and be released. Essentially, that's what was happening in Harris County. But
the other problem we have is that we have diversionary programs, but many of them require people to participate. Then they have to go to other meetings. They miss the meetings, and then they drop out of the system. There's 3,000 warrants outstanding for people in alcohol who were arrested for DWI. I don't know how many of those are people who were in diversionary programs that didn't complete them, and how many were out of state and couldn't afford to come back to participate in them?
Well, so there's an important question to be asked about whether the conditions of pretrial release are appropriate and tailored. The research also shows that over-conditioning people can cause pretrial failure. And so if you're going, it shouldn't be that every person who is charged with a DWI reflexively is sent to some pretrial alcohol abuse class. There needs to be an investigation into whether that's an appropriate condition for that person. Also, in a lot of places, those diversionary programs or certain conditions cost money. And it's not clear, either there's no opportunity to waive or reduce the fee, or if there is, it's not transparent. And the person's not told that. They're just told, don't come to class unless you don't have $25. They don't have $25, so they don't come to class. And then the warrant issues. So if, we shouldn't be turning immediately to extensive conditions and supervision. We need to be thoughtful, and we need to refer to the evidence and the data and the research that's been done to determine what level of conditions and supervision are appropriate for a given person.
Great, thank you.
Yeah.
I'm sorry I had to step out several times, and you may have covered this, but do you see any future at all in excessive bail challenges, and not really on, based on money bail, but on other conditions, sort of what you were just talking about? If you can address the issue of overconditioning.
Yeah, so the excessive bail clause in the Eighth Amendment, I think, can be interpreted in some ways. So one of the challenges that we've gotten, I'll talk about the money bail part first and then the other conditions question. We've gotten, the argument's been raised in a number of our cases, well, shouldn't this lawsuit have been brought under the Eighth Amendment? And basically, the analysis is essentially the same. There has to be a consideration of alternatives. It can't be more excessive, the bail amount can't be higher than is reasonably necessary to accomplish the government's goals. And so and some of the key cases that we rely on in our equal protection and due process arguments also cite Eighth Amendment cases. So I just wanted to make that point about the relationship between the 14th Amendment and the 8th Amendment in terms of excessive bail when it comes to actual money bail amounts. But your question was, I think, more specifically about the use of conditions. And it's definitely something that is problematic and concerning. We don't want to have the money-based pretrial system turn into 500,000 people walking around with ankle monitors on. And I do think that would be a serious due process challenge, a real problem inhibiting someone's liberty and their freedom. I haven't analyzed it under the excessive bail clause, to be honest, but I think that's the kind of question that we need to be asking right now while we're envisioning a new and better system. And so, when we're asking that question about how much risk do we tolerate as a society, part of that is paying attention to the fact that over-conditioning people causes pretrial failure, and that most people, the data show that most people can be released without conditions or with very minimal conditions. And we need to appreciate that using GPS monitoring is an extreme infringement on somebody's liberty.
I really appreciate this presentation, and I also really liked your discussion of the pros and cons of risk assessment. I guess the question I want to ask has to do with one of the things risk assessment can do, while you have to be very careful by potentially proxying for race and other issues that are very, when you have 15 variables and 10 of them look awfully close to race, that's problematic and from a legal standpoint. But one of the things that it does is it systematizes decision making. It potentially reduces disparity. And so I guess the question I want to ask is, are there ways to kind of have systematic decision-making from prosecutors and from judges in that can mitigate disparity, but then that also don't run into the problems that, say, risk assessment scores can do? What are some best practices in thinking about discretion and systematic decision-making to mitigate disparity and sort of achieving these justice challenges that you've raised?
Yeah, I mean, I think that's something I'd want to think about a little bit more. One possibility that comes to mind is sort of thinking categorically about certain charges that we just don't have a strong enough interest in detaining the person for. So somebody's charged with trespassing or theft under 750 or possession of some amount of drugs or whatever. Like, we can just release them. We can just cite them and release them and give them a court date. We don't need to do a risk assessment. We don't need to consider detaining that person. We could say, this is a person who, based on this charge, is just not going to be detained in our jail because it's not, we're just not concerned about this person categorically based on the charge.
But that doesn't address the issue of discretion and what are the optimal levels
of
discretion, prosecutorial discretion and judicial discretion. What would you say are best practices for that?
Are you asking how to get bias out of prosecutorial and judicial decision making? It's a really difficult question. I mean, I think part of it is having system actors educate themselves about bias in the system and about their own implicit biases and sort of analyzing that and recognizing it and then working to get beyond it. I'm not sure, as Dr. Holsinger was saying, there's not necessarily a better tool than these risk assessment tools, these needs assessment tools that we have right now, and they are a step forward. But I think we need to acknowledge that they're limited, and that baked into them, when you see a score of an 8 or a 9 or a 5 or whatever it is on the risk assessment tool that you're working with, you have to understand that baked into that is our systemic racism and classism. So I certainly don't have the answer to how to get all the bias out of our system, but I think a starting point is for people who are making those kinds of decisions, people who have power over other people's liberty, to recognize that they too are affected by these kinds of biases.
The women that you highlighted in the videos were very sympathetic, and it seemed like they were sort of victimless crimes. You know, they owed money for tickets or what have you. Have you done an assessment of people? I think there was another presenter who mentioned domestic violence type cases. Have you done an assessment of the types of risk assessment that's involved with that? I mean, you said ankle monitoring is a very heavy price to pay or infringement on someone's due process, but what about the victim analysis?
Yeah, I mean, I think those types of conditions might be acceptable. The problem, the constitutional problem, is that if you're going to infringe on somebody's fundamental liberty, you need to follow procedures and you need to make findings and you need to have really good reason. So there's our legal argument is not that no one can ever be detained. It's not that no one's dangerous. We're not arguing that there's no role that there's no concerns that are legitimate from victims or prosecutors of the state. What we're saying is that you can't impose some arbitrary amount of money as a mechanism for making that decision about how to keep the community safe. So yes, there's a role for victims' rights advocates. There's a role for domestic family violence cases may not be in those categories of cases where you automatically release a person. They might be a class of arrestees that you hold with no bond for 12 hours or 24 hours before they can have an opportunity to appear before a judicial officer who can make an individualized determination of the risk that that person presents and impose reasonable conditions of release. Or who can say, or the prosecutor can say in a particular case, you know what, this person, there's nothing that can keep the community safe from this person, and I would like the court to order him detained. And then the court can hold a hearing at which that person's represented and has an opportunity to present evidence, and then the judge will have to make a transparent order of detention to detain that person. But what we're arguing is that the community is not safer because you made that person pay $5,000 or $10,000 or $100,000 to be released. So if we're going to talk about whether and when to take away someone's pretrial liberty, our position is that, yes, that may be appropriate, but that the government has to follow rigorous procedures and make certain findings in order to do that. All right. Thank you all so much.
Thank you very much, Elizabeth, for the excellent presentation. I'd now like to invite our